Hey, America. So, first of all, new camera. Look at the blur in the background. How nice is that? Oh my gosh. Well, it's not a new camera. I had it around. I just learned how to set it up and use it for webcam. So, hooray. Hooray for technology. So, today I wanted to talk with my conservative friends and listeners out there um, who have been following the news with SB8 and who might think that that is a win for the Conservative Party. And I particularly want to talk to my friends out there who are listening, who are gun owners and who are Second Amendment fans. And I want to let you know how I see a connection between these things. And I think that no reasonable American should be in favor of what SB8 does, not particularly about abortion, but the way it goes about it and the precedent that it sets for just the dismantling of all kinds of other freedoms if somebody else just didn't like what they saw. So we have to start off with a few things, and I've been doing a fair bit of research on this myself, so I'm going to try and skip through the top points of it, but I do encourage you to check this out for yourself. So we're going to start with a concept called sovereign immunity. So sovereign immunity, it actually came from common British law, and fundamentally it means the king is imperfect and you can't sue him for anything that he does. We brought that into the United States. Cornell University has in their Legal Information Institute a definition of sovereign immunity, and it basically says that the government cannot be sued without its consent. Um, so you can't sue the government for passing laws. You can't, even if they might be later taken down as unconstitutional. You can't just sue them for doing that, and that's been established since as long as the country has been a thing. So that doesn't mean there's no recourse in the event that an unconstitutional law is passed. Obviously we've had them before, and there has been a resolution to those things. So another thing to learn along with sovereign immunity is this court decision called Ex parte Young that happened in 1908. And just quoting here from lexroll.com, which is just a law dictionary website. The case involved a suit filed by stockholders of a railroad company seeking to prevent the Attorney General of Minnesota from enforcing an unconstitutional state statute in violation of the 14th Amendment. So, in a nutshell, there was the Attorney General of Minnesota was trying to do something that other people thought was unconstitutional, and so there needed to be some sorting out of this whole concept of sovereign immunity. And what this does, what Ex parte Young decides, is that while the government can't be sued, the individual actors who are executing the law of their own actions, those people can be sued. So in a quote from the court at the time, I'll read this again. When the act which the state attorney general seeks to enforce is in violation of the federal constitution, the officer in proceeding under such enactment comes into conflict with the superior authority of the Constitution. And he is in that case stripped of his official or representative character and is subjected in his person to the consequences of his individual conduct. Okay, so let's think about how this all goes together. Sovereign immunity has been around since forever and says you can't sue the government for stuff. However, Ex parte Young, which was court precedent in 1908 and remains in effect to today, says that, yeah, you can't sue the government, but the individual actors within an organization that might work on behalf of the government, those individual players can be sued. So if a medical board was going to withdraw medical licenses from doctors that perform abortions, for example, then that suit could be brought against the officers of the medical board. If a police department stood outside and blocked access to an abortion clinic, then the officers who were involved, those members can be sued. So this is legal precedent, and it's been around for a long time. And why do I mention this? Because Senate Bill 8 was written with an understanding of this. They know the Supreme Court since 1973, when Roe v. Wade became the overriding decision on at a federal level about abortion. Since then, the Supreme Court has re-ruled on the subject of abortion another couple of dozen times. It is well established precedent that the right to get an abortion is constitutional, whether you agree with it or not. The right to get an abortion is constitutional, and our Supreme Court has upheld that for a very long time, over and over and over again. That doesn't mean it can't, that constitutionality can't change, right? I mean, we had the 18th Amendment that banned alcohol. Obviously, we got rid of that, right? So the things can change, and they do change over the course of time. But for the moment, the Supreme Court has not changed their fundamental position on Roe v. Wade. It is still viewed to be a constitutional decision and remains that way. Now, the people who drafted Texas Senate Bill 8, they know this. They know that what they're doing is unconstitutional. And they know that although you can't bring court case against the government because of sovereign immunity, you can sue the actors, the individual government leaders at the boots on the ground level who might be enacting the law, arresting people, or doing that sort of certainly interfering with somebody trying to get an abortion. And when when the law is challenged from a constitutionality perspective, that's the way that it would get challenged, would be through those individual actors who are upholding the Senate bill. That's the way it would go through, and those that wrote the bill understood that. So section 171.208 of the bill itself, it says any person, now listen to this, any person other than an officer or employee of a state or local governmental entity in the state may bring a civil action against any person who, and then it goes on with several bullets about performs or induces an abortion, knowingly engages in contact that aids and abets, or intends to engage in the conduct described by above. So you can even get sued if you intended to do it, even if you didn't actually do it. Notice that it says other than an officer and employee of the state, et cetera, et cetera. This SB 8 is not enforceable by the government. It is only enforceable by individual citizens because they're trying to avoid the opening that Ex parte Young allows for, which is for government agents to be sued in the event they're doing something unconstitutional. So they've made a bill that they don't ever intend to enforce themselves. They're looking to individual citizens to go out and do this to try and claim their $10,000 ransom, and under whatever individual moral, decision they have that they think abortion is wrong. So they're going to get out there and try and do something about it. That's it. So, okay. So let's just breathe that in for a second. Okay. You can't sue the government. In this particular case, you can't sue the people who are going to be executing on preventing abortions or bringing civil suits, because it's not the government. It was known. All this stuff was known. I'm not disclosing anything new. And the bill was crafted intentionally to get around this. Why do we care? Right? For those of you who are pro-choice, who are pro-life, anti-abortion, whatever way you want to, label your flavor, you might be thinking, well, that's fine. I mean, it's the end justifies the means. That it's okay to have a bill written like this, because at the end of the day, it's saving children's lives. I understand the people who are pro-life and who are anti-abortion are doing so on the fundamental belief that they're saving the lives of children, and that's obviously very difficult to argue against. The concept of viability of life and things like that is another video, another day. But what we really want to talk about here is the power of this law and what it could do down the road. So let's take abortion out of it for a second and just look at it abstractly. There's a group of people, a minority, by the way. The majority of Texans agree with a woman's right to choose. So a vocal moral minority happens to have a governor that agrees with them, and they pass a bill that makes something that is otherwise constitutionally protected illegal in this state. And you cannot go after the state or any of its actors for enforcing this unconstitutional thing, because they don't enforce it. They're leaving it to individual citizens with this bounty money to do it. This is why I am calling out to my friends and listeners who are gun owners. Go and do the math on that one too. Gun owners, even in Texas, you are in the minority. More people, more Texans, more Americans broadly, but more Texans believe that gun control, some reasonable measure of gun control, is better than what we have right now. Those that think the Second Amendment is absolute and you should be able to have whatever you want, and that's it, and any form of governance around guns is violating the Second Amendment, fine. If you want to believe that, fine. Well, this is a debate for another day. But if that's the case, you need to recognize that you're in the minority. I talked about this in another video too. And if we're going to establish precedent that somebody who is in power can pass laws that are blatantly unconstitutional and make bounty hunters out of citizens to enforce a bill that's unconstitutional, today it's abortion. Tomorrow, what is it? Is it gun rights? Is it freedom of speech? What is the next thing that some noisy minority is going to get somebody in charge to pass a bill to support? This believe what you want about abortion. Believe what you want about gun rights. Believe what you want about any of this stuff. That's one of the amazing things about our country, right? We all get to believe our own different things. And that's perfectly fine. But we all of us, top to bottom, side to side, all Americans should agree that governments passing laws that they know are unconstitutional with language intentionally built to avoid any kind of suit being brought against them to challenge their unconstitutionality and turning citizens against each other is a fundamental bad idea. It is beyond a slippery slope. It's just an entirely bad idea, and it is something that as Americans we should not support. Greg Abbott and anybody else who supported this Senate bill should be, well, there's a vote coming up, isn't there? And we should be communicating clearly with our vote that this is not the way it's going to work. Republicans, religious right people that support pro-life, whatever your position might be, there are other freedoms that you have that you want less restricted than other people think. And if we just leave this to the noisy minority and turn Americans against each other, it's going to go in the wrong direction in a hurry. We should be together on this one. I don't see any other way around it. Anyways, go do the research for yourself. Learn about these things. Sovereign immunity, Ex parte Young. I would strongly advise you to go read the bill for yourself, and then see what you think. This is the way I see it. It's probably not the only way, but in the spirit of common ground and bringing people together, I couldn't sit quietly on this topic of Senate Bill 8 and not address the gorilla in the room, that this is intentionally built to divide America, which is the opposite of what our government should be doing. So anyways, happy Labor Day.